Hello and welcome. I'm Otis Landerholm. I'm the founding attorney here at Landerholm Immigration, A.P.C, where we fight for your American dream. And today I'm here, unfortunately, with some bad news. Just yesterday, I'm filming this on the 11th of June of 2020, and I'm going to share my screen here. And just yesterday, the Justice Department came out with a new proposed rule for asylum cases. All right. So this is not a law that Congress would have to pass. This is a proposed rule or a regulation change, which the Justice Department and the Department of Homeland Security can do because they have their own rulemaking bodies, as long as they do it in accordance with the law that's spelled out in the Immigration Nationality Act. Which my reading of this is I'm pretty skeptical that the Justice Department and the Department of Homeland Security will actually do it in line with the law. My guess is there will be legal challenges to these proposed regulations. What I'm looking at here is just a press release from the Department of Justice, and they're talking about the notice of proposed rulemaking. And what the notice of proposed rulemaking says is certain changes. And I've highlighted the ones that I want to talk about. These are just the bullets that was in the press release by the government. There's 131 pages of a proposed rule change. I haven't gone through the whole thing yet. Right now, I'm still digesting this, but I wanted to show you what this press release from the Department of Justice talks about. And then I can do a more thorough training. And in our office, we can do a more thorough training regarding these proposed rule changes. All right. So the first proposed rule, all right, says that it'll amend the regulations governing credible fear determinations. All right. So that individuals that have a fear will have their claims for asylum, withholding of removal, or protection under the Convention Against Torture adjudicated by, and then I highlighted this, by an immigration judge in streamlined proceedings rather than in immigration court proceedings conducted under Section 240 of the Immigration Nationality Act. All right. So they want to go streamlined, which when I hear that, I just think, okay, they're not going to be as thorough, not as rigorous. They're going to make quick and dirty decisions. And that's going to cost people their safety. All right. People are going to be deported back to countries where their lives are in danger without having somebody really listen to them. All right. So that's the first. The second change, according to this press release, is they're going to allow or permit immigration judges to pre-termit. All right. I've highlighted that. Asylum applications without a hearing if the application, quote unquote, does not demonstrate a prima facie eligibility for relief. So what does this mean? Unfortunately, this means that if you're filing for asylum, you'd better do it really, 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 really well from the outset. Because if you haven't met all of your arguments right from the initial stage where you're saying, hey, I'm afraid for my life to return to my country, then they're going to pre-termit, which means they're going to just say no. All right. They're going to deny, all right, your application for asylum without even giving you a hearing. All right. That is not good. All right. The third thing they're going to do is they're going to clarify when an application is frivolous. We'll read the full regulations to see how they're going to clarify that. Probably not good, right? Fourth, they're going to clarify standards for the adjudication of asylum and withholding claims, including amendments to the definitions of terms like particular social group, political opinion, persecution, and firm resettlement. These are big legal issues that are often fought about in an asylum case in immigration court, all right? Whether someone is afraid for their life to return to their country because of their membership, for example, in a particular social group, or because of, for example, their political opinion, all right? And what level of harm rises to the level of persecution. I mean, these are important concepts in an asylum case legally. And so how are they redefining these terms, and how are they doing it in a way that makes it more and more and more difficult for someone to seek this type of relief, all right? The next, it says that they're going to be outlining factors for adjudicators to consider when making quote unquote discretionary determinations. All right, so what does that mean? We'll have to read the full rule and get that. I'll do a presentation on this to get that clear. All right, next they're saying they're going to clarify the standard for determining quote unquote the acquiescence of a public official or another person acting in an official capacity under the CAT regulations. CAT stands for the Convention Against Torture. And to win a CAT claim, we've got to show that someone in your home country is going to torture you, and it's either got to be the government themselves or it's got to be someone acting in the acquiescence of the government. All right? And so what does this term acquiescence of a public official talk about? And that'll make that'll have huge ramifications for people being denied CAT, sent back to their country, then getting tortured, but it wasn't quote unquote at the acquiescence of a public official, so we can just send them back to go get tortured. All right, I mean that's really really nasty to be messing with the Convention Against Torture. All right, the next says it'll raise the burden of proof for the threshold screening of withholding and CAT protection claims from significant possibility to a slightly higher standard of a quote-unquote reasonable possibility standard, all right? Right now, the standard on those types of cases, if you've got to show a quote-unquote significant possibility to even get into immigration court, to even start the process. And right now, they're going to raise that standard, to make it more challenging to even put yourself in that process, all right? The next, they say they're going to apply the bars to asylum and withholding when making credible fear determinations. So again, the credible fear determination is like the first step of the asylum process. So now they're going to be applying the bars to asylum. For those who don't know, there are 9 bars that could bar a person, prohibit a person from even seeking asylum to begin with. So this is saying they're going to apply those even at that initial stage, which is the credible fear determination stage. Lastly, they say they're going to clarify the requirement to protect certain information contained in asylum applications. All right. So this is just a very quick overview of the press release that the Department of Justice and the Department of Homeland Security issued late yesterday. And, we're talking about huge changes, systemic changes that'll just make it more and more and more difficult for people who are fleeing for their lives to seek asylum or withholding of removal, to seek protection here in the United States. Really, really disappointing to see. I'm going to stop my screen. Really disappointing to see. We want a country that welcomes people, especially people who are afraid for their lives, to go back to their home country. All right. The whole purpose of asylum law was like, okay, after World War II, you've got Jews that are fleeing from Nazi Germany, all right? And if people are going to go back to Germany, they're going to get put into concentration camps, killed, tortured, the whole thing, all right? Like, our asylum laws are critical to the functioning of our society and to our society being a place in the world that does not tolerate torture, abuse, persecution, serious violence in other parts of the world. And we should not allow the president and our current administration to undermine what is like so critical to the fabric of our whole country. All right. So asylum law is serious. We should not be undermining it. I'll be doing more videos about this. But in my opinion, these are ridiculous proposed changes and amendments, undermining yet again our U.S. asylum protections. All right, thank you so much for watching this. I'm Otis Landerholm, Landerholm Immigration A.P.C, where we fight for your American dream. Thank you.